It is time now for today's Talkback segment. Defense attorneys for accused killer Bryan Kohberger have received the okay from the judge on the case to continue phone surveys of potential jurors in Latah County. Kohberger's defense team hired a consultant to survey potential jurors living near the university about things that they might have seen, heard, or read about the case. Now, this comes after state prosecutors argued that these surveys could potentially prejudice the jury pool by violating a broad gag order previously issued by the judge. But the judge concluded that most of the questions being asked in these surveys were already publicly available, and so he allowed it. Today we asked you, should the defense be allowed to survey potential jurors? All right, joining us is civil rights and criminal defense attorney Sue Ann Robinson and national trial attorney Michael Jaafar. All right, guys, our first comment comes from Donna. Donna says, ridiculous. I think they are doing this specifically to taint the jury pool. They wanted to change a venue and will use this tactic, saying they couldn't find jurors. Appeal. I don't understand the logic of this judge at all. Michael, I'll start with you. I totally get where she's coming from on this one, because the argument could be made, even though this stuff's in the public record. Some of it's been on television, televised, some of it written about in local press and media. There's still plenty of people who may not know some of the information that's being put out, specifically some of the misinformation that's being put out, because they're using that as well, because that's in the public domain. But yet the judge felt that it was okay to protect the rights of the defendant. Your thoughts?
Judge made an excellent decision. I was worried about a month ago. I thought he was trending towards not allowing it. And here's what I've said. Due process is always inconvenient for a lynch mob. The viewer who posted that, I'm not saying she's part of a lynch mob, but she might be part of a lynch mob. Due process is supposed to be inconvenient for a lynch mob. And I 100% agree that they should be allowed to ask these questions. How are you going to taint a jury pool that's already tainted beyond tainting, right? How could you possibly taint a jury pool by asking a question that has been reposted 17,000 times a week on Instagram and TikTok? How? You can't possibly taint a jury pool by asking them a question, because what if the answers come back, yeah, I've seen these questions, Michael, by the way, and they're very, very reasonable questions. What if an answer comes back and says, hey, I have heard about this evidence on this fingerprint, and I think that he did it, and let's just say that's wrong. Wouldn't you want to know? Due process is supposed to be inconvenient. And the other thing she said was because they want to move the venue. I think they should move the venue even before this happens, right? 200 years ago, if somebody murdered someone in Cleveland and you moved the trial to Detroit, no one in Detroit has read the Cleveland Herald, which is 180 miles away, right? So you could move a venue 200 years ago and nobody's heard of it.